Well, hey folks, I'm back again, and I want to talk to you a little bit. It's not that I just only have the one shirt. It's just I'm trying to do as many of these as I can in one day, and then I'll come back in another day with a different shirt, I promise, and I'll do a bunch more. But, you know, I've got to do 16 of them all together, so I'm trying to knock off as many as I can. So anyway, this case I want to talk to you a little bit about this time is O'Brien versus United States, or United States versus O'Brien. Full case citation is 391 U.S. 367. It's a 1968 case. And here again, you hear these certain years, and they should tell you, they should trigger things. In that particular instance, Vietnam War years. So, big time of my life. Afraid I was going to get drafted, for example, this type thing. Big deal here is that David O'Brien burned his draft card on the steps of the Boston courthouse. It's probably a county courthouse actually, but it's in the city of Boston. Saying he was just expressing, it was a form of performance speech. In other words, he was demonstrating that he was opposed to the Vietnam War. And so his way of demonstrating his opposition was to burn his draft card. Well, apparently there was a federal law against burning your draft card, and he was convicted under this federal law. And so destruction or mutilation of a draft card was a crime. Now, right away, I'm concerned about a law like this because they give you a cardboard card back in those days. I know it was cardboard because I happen to have one. And basically you fall down in the mud, you ruin your draft card. It was an accident. I mean, are they saying that, you know, mutilating your draft card, you know, even if you ruin it in the mud, for example, that would be a crime? You know, so it's some of these are a little bit suspicious in my mind anyway. So the issue then was, though, that he consciously stated that he objected to the Vietnam War and he was burning his draft card. So he was knowingly mutilating his draft card, which would be a pretty good strong element of a crime if it was a crime. But remember the times, you know, this was a pretty open-minded court during this time. This was still the Warren Court. But frankly, it's a little bit surprising to me. But in a 7-to-1 majority, basically they came up with a test that said that certain symbolic speech was justified, but the formula has to examine whether the regulation is unrelated to content and narrowly tailored to achieve the government's interest. Warren says, we think it clear that the government regulation is sufficiently justified if it's within the constitutional power of the government. And so if it furthers an important or substantial governmental interest. And so basically that they wanted you to have your draft card and that, you know, it had numbers on it and things that were important. And so it would be, you know, pretty important that you have a draft card is what they're saying. So they're saying is, yeah, you can express yourself, you can verbally express yourself, but when you start destroying government property, which, you know, technically your draft card is government property. Even though you're carrying around on your person, you're carrying around government property. So they don't want you to destroy government property. So by a vote of 7-to-1, they voted in favor of the United States and said that, yeah, you can be prosecuted for burning your draft card. And so basically that was the decision way back in 1968. Citation again, 391 U.S. 367, parentheses, 1968, close parentheses. So this is one decision, and it's basically saying that, you know, hey, if you're destroying an item of government property, then that could be a crime as a sort of demonstration of your speech right in that way. So it's probably not freedom of speech to destroy any kind of government card, even though it is just a little cardboard card. Well, the next case, and this is kind of set against that last case, which again was the O'Brien versus United States, or United States versus O'Brien. But the next one I want to bring up is this case of Texas versus Johnson. And this is one that comes up a lot. And this is 491 U.S. 397. And this is a 1989 case. And 1989, as times have passed, we've gotten a little bit more conservative than we were in the 60s, believe it or not. But, you know, in that particular case, question was whether Gregory Lee Johnson was allowed to burn an American flag. Now here again, the pervading question is, whose flag? Was it his flag? Did he buy the flag? Well, that's a lot different than burning a draft card that was issued by the government. That is government property. So that's a bigger question. So the asking point here is, well, how about it? If you burn a flag, should you be prosecuted? And so basically he was prosecuted under a Texas law that made it illegal to desecrate the United States flag. And so he was sentenced to 1 year in jail, and he was fined $2,000. And he was doing this because he was opposed to the Reagan administration and their policies. Well, in this particular case, the court, by a 5-4, which is a narrow margin, said that he could burn a flag. In other words, he can burn his own flag to illustrate as a kind of a performance speech that, you know, hey, I'm opposed to Ronald Reagan. I think what he's doing is bad. And so this is how I'm going to illustrate it, is by bringing attention to it, by burning a flag. And so basically, here again, you know, you have the right of free expression of your ideas. And, you know, sometimes a performance speech is like if you act in a play, or, you know, you pretend to basically cut your throat or something like that, or hang yourself or something like that, to try to demonstrate your views as a form of speech. In other words, there has to be some way that people should have some leeway to perform their speech, because if people can't hear, for example, how are you going to get your point across? And it's often been said that a picture is worth 1,000 words. So if you illustrate it by some kind of performance, like burning the flag, you might get more attention drawn to yourself than just by standing on the steps and saying, I'm opposed to Ronald Reagan, for example. Well, this case again, 491 U.S. 397, open parentheses, 1989, close parentheses, Texas versus Johnson, reaction to Ronald Reagan by burning the flag. Narrow margin victory for Mr. Johnson. The individual does have the right to burn the flag. Of course, then the question is, what if he tears down, let's say, the flag from the courthouse and burns it? Is that different than bringing your own flag and burning it? I'd say yes, based upon the case with the draft card. If you're burning somebody else's flag, that's destruction of someone else's property. I think that's a lot different than just having this demonstration of speech that you are burning your own flag. Just something to think about. Well, hey, another couple interesting cases, another twist and turn on freedom of speech. We'll go through these a few at a time. Not going to cover every one, like I said, but we have quite a few to cover in Chapter 11. As you notice, that list is really long. So I'm going to keep working through the list and pick out certain ones that I think that are important. So those are the ones we're covering for this time, for this video lecture. Hope you enjoyed it. We'll be back at you with some more here real soon. Thank you.